welcome to Requiro. Today we're going to be talking about the transcript that came out on the 9th of January 2026 of when Luigi Mangione had his hearing on that date, and this is basically the full transcript of that day. If it's just a audio version of the full transcript, you guys want to listen along or don't really have the time to read it because it's literally 92 pages long. And this video is a little bit different because I haven't really made a dedicated video of going over a transcript before. I went over the live tweets and stuff for the December suppression hearings in Luigi Mangione's case until we get official transcripts for that. We're not gonna go over my beef today about the free Luigi Mangione sub transcripts. I've went over that multiple times in my previous videos, and I'm not sure if I'm going to do a little breakdown or things I want to bring up in this transcript like I've done before in the past of the live tweets where I brought up things that I thought are incredibly important to bring up. So I'm not too sure if I am going to do that or not with this transcript, so I'm not too sure. I know you guys like them when I do little shorts and stuff of bringing up things that are incredibly important and little breakdowns and stuff, so let me know in the comments down below if you guys want me to do that. But basically this video is a audio version of this full transcript, so you guys can just listen along and know what happened on this day. Again, I'm playing catch up with all the documents at the moment, so sorry if you guys miss my face when I do my longer videos. Anyway, now I want to say a massive thank you to missidcullen. I don't know if I'm saying that right. I'm sorry if I butchered your username, but a massive thank you to this person on Reddit. They are in the Murder Brian Thompson subreddit. A massive thank you to them. They basically just put this full transcript in a Google document for all of us to read and enjoy, and shared the link in that subreddit for us to read and enjoy. So a massive thank you to them for doing that. So that's where I got this document from, so I can read and show you guys. Also, side note, I'm looking at myself in my viewfinder on my camera, and oh my god, I did not realize how much my microphone is blending in to my shirt. They are very similar designs. It is blue with white with very, very pretty European patterns. Oh my god. I thought they looked similar. It's oh yeah, it won't be too bad. No, my microphone's literally blending into my shirt. Oh my god. I swear, ever since getting that Dolce & Gabbana mocha pot that I bought last year for my birthday, oh my god, absolutely gorgeous. Ever since then, I've been utterly obsessed with this type of pattern of the blue intricate design. Incredibly European design. I've been utterly obsessed with that ever since I got that. I don't know why. You can clearly see with the microphone. And now my shirt. I have about 3 things that are exactly the same. It's blue, it's incredibly European, it's absolutely gorgeous. I love that shit so much. I absolutely do. Blue, gorgeous European shit. I love it so much. And all the information and all the sources I use in this week's video will be up on the website for this week's episode, so if you guys want to go read the Google document, go ahead, it's all going to be there, so you guys can go read and enjoy instead of, listening to my Suri read it out to you guys. I refuse to use AI. I want you guys to know I am using my computer that Apple's software is built in than using AI. It sounds like a robot, but it's better than the AI shit that sounds fake as fuck. Anyway, one day I'll be rich and gorgeous. I'll be able to afford a real human being to read it out to you guys. But for now, you guys get Suri. And normally I would say if there's anything I got wrong or anything like that, please let me know in the comments down below, and I'll sure to pin it or bring it up in my next video. I am one person working on all these videos. It's kind of amazing. I swear I put way too much work into these videos, but I think it's worth it. I think in the end, I don't know. Anyway, enough of me yapping on about random things. Let's get into the video.
Q19H Man C. United States District Court Outturn District of New York Y United States of America, Volume 25 CR 176, MMG, Luigi Mangione, Conference Defendant, New York, NY January 9, 2026 11:10 a.m. Before, Hon. Margaret M. Garnett, District Judge. Appearances J. Clayton, United States Attorney for the Southern District of New York by Dominic A. Gentile, June Zhang, Alexandra S. Messiter, Thomas John Wright, Assistant United States Attorneys, Anafilo Intrator LLP, Attorneys for Defendant by Mark Anthony Anafilo, Karen Friedman Anafilo, Jacob Kaplan and Morskowitz, Colson, Ginsberg and Schulman LLP by Avraham C. Morskowitz, EYLAN Schulman, Christopher R. F. Paresh Patel. Also present, Sophia Anafilo, Defense Southern District Reporters, PC 212-805-0300. The Deputy Clerk, United States v. Luigi Mangione, Case Number 25 CI 176. Counsel, please state your appearances for the record, starting with the government. Mr. Gentile, good morning, Your Honor. Dominic Gentile, June Zhang, Alexandra Messiter, and Thomas John Wright, for the United States. The Court, good morning. Ms. Friedman Anafilo, good morning. Karen Friedman Anafilo, Mark Anafilo, Paresh Patel, Avi Morskowitz, Jacob Kaplan, Elin Schulman, Chris Neff. On behalf of Luigi Mangione, also at counsel table is Sophia Anafilo. The Court, all right. Good morning, everyone. You can all be seated. Ms. Friedman Anafilo, good morning, Your Honor. The Court. So, just a couple of housekeeping matters before we begin, and that's we do have a live feed to an overflow room. I just want to tell all counsel and Mr. Mangione that the audio is very sensitive on the feed to the overflow room, so if you need to confer with one another or, Ms. Friedman Anafilo, if you need to confer with your client, even if you think you're whispering, it's very important that you mute your microphone and any microphones that are near you if you need to confer in a way that should be private between counsel or between counsel and Mr. Mangione. We have a full house here today, so some of you may not be familiar with how we do things here, but this is a federal courtroom. It's very important that decorum be maintained. What does that mean? That means there's not to be any outburst from the gallery. No one is to stand unless they're instructed to stand. There's a small number of you that are allowed to have electronic devices with you. I would just ask everyone who's in that category to take a moment, make sure those devices are fully on silent. If any device makes any noise during the proceeding, the device will either be confiscated or you will be removed or both. So just take a moment to do that. I apologize. Like everyone in New York City, I seem to be getting over a cold, so I apologize for my raspy voice, and a cough drop may have to be employed. Pending before the court, and our purpose for being here today, are a number of defense motions. First, a motion to order the government to provide additional information on the aggravating factors it intends to prove at any potential death penalty phase. Second, a motion to strike the notice of intent to seek the death penalty on a variety of grounds, both constitutional and otherwise. Third, a motion to dismiss counts 3 and 4, which, in sum and substance, charge the defendant with discharging a firearm in furtherance of a crime of violence and committing murder with a firearm in furtherance of a crime of violence on the ground that the charged predicate crimes of stalking do not qualify as crimes of violence as a matter of law. And fourth, motions to suppress statements the defendant made at the time of his arrest and to suppress the contents of his backpack seized at the time of his arrest. I know we had discussed last time we were together setting a trial date at this conference, but because the outcome of the defendant's motion to dismiss counts 3 and 4 will significantly affect the timeline of any trial in this matter, I don't think we can do that today. And just to add a little more color to that and explanation for the public that is here, if I were to grant the defendant's motion to dismiss those 2 counts, the defendant would still be facing a potential sentence of life imprisonment, but this case would no longer be capital eligible under federal law, which would, of course, moot a number of the defendant's other motions and make scheduling and conducting the trial significantly easier. However, if I were to grant that motion, the government would have the right to appeal that decision to the Second Circuit, which could materially delay any trial on the remaining counts. If I were to deny the defendant's motion to dismiss, I would then proceed to decide his motions addressed to the potential death penalty in this case, and then we would reconvene promptly to set a date for the start of jury selection and for the start of the trial. So given the pivotal importance of the motion to dismiss counts 3 and 4, I have instructed counsel to be prepared to argue that motion and to answer my questions today. Now, before we turn to that, I just want to spend a little bit of time on the suppression motions. The defendant originally filed 2 suppression motions, one to suppress his statements made to law enforcement officers at the McDonald's restaurant in Altoona, Pennsylvania, where he was arrested, and 1 to suppress the contents of his backpack seized from the McDonald's at the time of his arrest. As to the first motion, in light of the government's representation that it would only seek to offer at trial 2 statements the defendant made identifying his name as Mark or Mark Rosario, and, in reliance on that representation, the defendant has informed me that he intends to withdraw his motion to suppress his statements. I just want to confirm with you, Ms. Friedman Anafilo, that is still the defendant's intent. Ms. Friedman Anafilo: Yes, Your Honor. The court: All right. So, accordingly, that motion is denied as moot. Turning to the second motion, in my December 31st order, while I noted that I did not need oral argument on the legal issues in the motion, I did ask counsel to provide the court with their views as to whether an evidentiary hearing was necessary to address the government's arguments regarding 2 exceptions to the warrant requirement urged by the government, a valid inventory search or the doctrine of inevitable discovery or, of course, any other aspect of the defendant's motion to suppress the contents of his backpack. I also asked counsel if they believed an evidentiary hearing was necessary to identify the specific facts that were either disputed or unknown but necessary to resolving the motion. In response, the government asserted that no hearing was required because, at a minimum, the inevitable discovery exception concerns a question of law that can be decided by the court on the present undisputed record. The defendant, however, asserts that a hearing is necessary, primarily, as I understand, for 3 reasons. First, that there's a disputed question of fact as to whether the backpack falls within the Altoona Police Department's written policy on inventory searches. Second, because a hearing would illuminate whether the court can consider Government Exhibit 5 in deciding the first question, because Exhibit 5 is an undated document from training materials for probationary officers in the Altoona Police Department. And, third, because the court should look at the actions actually taken during the purported inventory search by Altoona police officers and determine that those actions exceeded the bounds of a proper inventory search, primarily by reading some of the contents of a journal found in the defendant's backpack. I'd like to take those in reverse order. So starting from the third issue, I don't see a basis for a hearing on that issue because the Mendez factors specifically contemplate an assessment of the hypothetical search that would have been done pursuant to established procedures rather than looking at what officers actually did. In other words, what Mendez teaches, and the cases citing it in the circuit, is that the court has to be very careful not to conflate the inventory search exception and the inevitable discovery exception. And here, looking at inevitable discovery, what officers actually did is of limited, if any, relevance. And as to the contents of the journal, the government also points out in their letter that later search warrants allowed for access to the contents of the journal, and those warrants were obtained without reliance on those contents to establish probable cause to search the journal. So without even getting into the government's waiver argument in its January 8th letter, I don't see a basis for a hearing on that particular issue. Mr. Anafilo, is there anything additional you would like to say on that particular argument? Mr. Kaplan: Judge, just briefly, the court, if you could identify yourself for the record. Mr. Kaplan: Jacob Kaplan. In Mendez, the court was determining whether, if the policy and procedures were followed, the evidence would be recovered. The purpose for our argument is to say is that if those policies were followed in this case, they still would not have had permission to go ahead and read the contents of the journal. It's no different if they recovered a laptop or a phone, just based on the inventory rules, which will allow them to inventory the fact that they recovered it. That would not give them permission to go and open the laptop or open the phone. It's no different here than the journal. The inventory procedure would allow them to mark the fact that they recovered a journal. It would not give them, under their guidelines, the right to go ahead and read the journal, read the contents of the journal. So under Mendez, I would say, the court, let me just stop you for a minute because I certainly understand that, but I think the point that I'm trying to make is that, fine, they did that, and it appears undisputed that some of the officers did read some of the contents of the journal, but the government is not relying on the fact that those officers read through some parts of the journal in the course of making their inventory search, rather for the contents. They've explicitly said that those contents were permissible by a court-authorized search warrant, the affidavit of which made no mention of the contents of the journal. So the question for the exclusionary rule is, what are we trying to deter? And normally, as I understand Mendez and the other inventory search cases, there's kind of a presumption that something improper has happened, right? The only reason you get to an inevitable discovery exception or inventory search exception is because, at some point prior to that, the evidence has been obtained in a way that arguably exceeds the bounds of the Fourth Amendment. So, given the government's argument about the journal specifically, why do I need an evidentiary hearing to find out in my own court, under oath, what those Altoona officers did with the journal? Mr. Kaplan, to the extent that the government is relying on this concept of inevitable discovery through a search warrant, which they mention as a footnote, the question would be, and what the court needs to decide is whether or not there was enough evidence, enough allegations in the search warrant absent the allegations relating to the search of the backpack, because they've not provided the court with the search warrant, right? If the court reviews the search warrant, the court will see that they actually did reference the illegal search of the backpack. The court, right? But we have to take each piece of evidence separately, right? So I understand the search warrant referenced items recovered from the backpack, but as to the journal specifically, the government has represented that the affidavit did not discuss anything that was written in the journal that arguably should not have been read in the course of an inventory search. Mr. Kaplan, but that's not the question. The question is, in the search warrant, absent reference to the illegal search of the backpack, forget the contents. The question would be, is there enough in the search warrant? Once you take out all the references to the illegal search of the backpack, forget the contents of the journal, the actual illegal search of the backpack, whether or not there's enough left in that search warrant to justify a probable cause for them to search the backpack and the journal. So it's two separate, really, issues here. The court, right? But you're assuming that there's no other valid exception that would apply to any aspect of the backpack search because the government, yes, in a footnote, argued that everything in the backpack would be inevitably discovered because of the warrants, and I should pass the warrant to remove any reference to its contents. But what I'm asking about now is just specifically about the journal. I don't think there's any dispute that the journal, the contents of the journal, are not referenced in the search warrants obtained by the government or by the Manhattan District Attorney's Office. Is that correct, Mr. Kaplan? So in the search warrant, which, again, the court has not been provided with the search warrant, but in the search warrant, the court, I can solve that problem, Mr. Kaplan. Yes, hopefully, we can. In the search warrant, there is reference to the fact that law enforcement did obtain pictures of what was inside the journal. In other words, the Altoona Police Department took pictures of every page of the journal. They gave that to federal law enforcement. Federal law enforcement reviewed those pictures, and what they're saying is, yeah, we reviewed it, but nothing in this warrant is relying on those contents, right? That's the assertion that they made. You know, what my point is and what our point is that the court can't simply focus on the contents of the journal. The court should focus on whether, when we remove the illegal nature, the illegal information that they had, in the total search warrant, is there enough probable cause to support it? Only then, only if the court finds that there was enough probable cause absent not just the contents of the journal but the contents of the backpack, if the court determines that, then the court can say, okay, it's a valid search warrant. That valid search warrant will allow them to search the contents of the journal. But the court can't jump to the final step and say, well, they didn't rely on the journal contents, therefore, the search warrant's okay. That's not the concern. The concern is they relied on the contents of the backpack, which, at the end of the day, we have very good arguments to show that that was illegal. The court, right. But in analyzing any suppression issue, don't I have to address each piece of evidence that the government might want to offer at the trial? I mean, because, really, this is what, the only relevance of this question is if the government has evidence that they intend to offer at trial against Mr. Mangione, right? So what officers did or didn't do might be relevant to a civil lawsuit, but the question that a suppression motion has to decide is, as to each piece of evidence that the government might seek to offer at trial, should that evidence be suppressed? So I definitely understand that you have arguments that would lead to the conclusion, if I accepted them, that the entirety of the contents of the backpack should be suppressed. I understand that, but in terms of the analysis and the need for any kind of evidentiary hearing, am I correct that, assuming that I rule for the government on either inventory search or inevitable discovery for everything else, other than the contents of the journal, and then the government is relying on the search warrants that were obtained, and I've already decided that everything else was lawfully seized and does not need to be suppressed, then isn't the proper question whether the contents of the journal were used to obtain the search warrant, and if they were, and I excise any reference to that, if I think the search warrants still establish probable cause, that would be kind of a two-step inevitable discovery for the journal. Mr. Kaplan, if the court would follow that process by which it would find that the contents of the backpack, forget the journal, the contents of the backpack would be admissible under inevitable discovery plus inventory search, then I guess what the court is arguing or saying is that they, therefore, can rely on the contents of the backpack in support of the search warrant. The court, well, that's my question to you. If you have a disagreement with how I have set out the analysis, Mr. Kaplan, so I think if the court would find that, based on the inevitable discovery based on the inventory search, right, which I think the court should have a hearing on the court, right, we're going to get to that in a minute, one thing at a time, Mr. Kaplan, so, yes, if the court finds that, then I would agree with the court's analysis that once the court has found that the contents of the backpack would be okay based on some other reason and the only issue would be the contents of the journal, then the court would have to look at the warrant to see whether, taking out any reference because there are references to the journal, if there's probable cause. So I would agree with the court on that. The court, all right, that's very helpful. Thank you, Mr. Gentile. I don't mean to leave the government out of this. Is there anything on that specific issue that you'd like to add, or Ms. Messiter? Mr. Gentile, Ms. Messiter is going to handle that issue. Thank you, Judge. The court, Ms. Messiter, on that particular question, anything that you'd like to add, Ms. Messiter? No. As Your Honor suggested, the government is not relying on the inventory search or inevitable discovery doctrines as to the contents of the notebook, but rather on a traditionally authorized search warrant allowing the government to search those contents, and that warrant application expressly disclaims reliance on the contents of the notebook. None of those contents were included in the warrant, and so they weren't before the judge making the probable cause analysis there, and so, just as Your Honor has suggested, as long as there are, as we submit that there are, valid exceptions as to which the other contents of the backpack fall, that warrant would cover the contents of the notebook, and no hearing would be necessary on that front. The court, all right, thank you, Ms. Messiter. Mr. Kaplan, this may be a technical point, but it seems the government is relying on inevitable discovery through a search warrant, so I think it's incorrect to say that they're just relying on the search warrant. In their own motion papers, in the footnote they say it's inevitable discovery because of the search warrant, so they're marrying the two together. It's not independent, just a search warrant. The court, well, yes, I understand that. For many of these issues, there's multiple steps required, so thank you for raising that, but I think I do understand that point. But while I have you, Ms. Messiter, as to the second argument, whether Exhibit 5 could be considered by the court without an evidentiary hearing, so let me just ask you whether the government intends to rely on Exhibit 5 for your inevitable discovery arguments or whether you think Exhibit 6 is sufficient for that. And just for those following along, Exhibit 5 is an undated document from the Altoona Police Department related to training of probationary police officers. Exhibit 6 are general orders from the Altoona Police Department. Ms. Messiter, Your Honor, Exhibit 6 is sufficient, in the government's view, to rely on to establish that the Altoona Police Department had an inventory search procedure, pursuant to which all items taken from those arrested or detained would be searched. That said, Your Honor, we do think that Exhibit 5, it's clear from the face of the document, which sets forth operational procedures, that it is the current procedures of the department. However, Your Honor, we do think the court, I'm sorry to interrupt you, Ms. Messiter, but on what basis am I supposed to know that that document reflects the current procedures of the Altoona Police Department, or, more importantly, those that were in place in December of 2024? Ms. Messiter, Your Honor, the document is headed at the top Custodial Arrest Procedures, Summary, Misdemeanor, and Felony Offenses, and the specific provisions on which we are relying is within a section entitled Operational Procedures. And so we think it is clear from the face of the document that these were the procedures in place for the police department. The court, well, I'm just struggling with that a little bit, Ms. Messiter, because while I certainly accept the government's representation, I can't make an evidentiary finding based solely on the government's representation, I think, and it would be common for police departments to revise procedures, to have old things in a drawer that have been superseded by other procedures. And so I just want to press you a little bit on the basis on which I can accept the government's representation that that document reflects procedures that were in place in December of 2024, Ms. Messiter. So, Your Honor, we would again reiterate that we do think, to be clear, that the general orders are sufficient to resolve the questions at issue. If Your Honor needed further fact-finding as to the dates during which this custodial arrest procedures document was in effect, the government could, of course, call a single witness from the Altoona Police Department, limited to that question of, was this document the procedures in effect during the relevant time period? But, again, we don't think that exercise is necessary because we think that the general orders are sufficient for resolving the questions before the court. The court. Thank you, Ms. Messiter. On that issue, Mr. Kaplan, anything you'd like to add? Mr. Kaplan, I agree with the court about Exhibit 5, but about the general orders, I would just say it's unclear from just reading the face of the general orders that it would apply to both the search, inventory search of the defendant's person as well as any belongings he may have had. The court. We're going to get to that. That's question number 1. But, again, just one thing at a time. So specifically on the things, my conversation with Ms. Messiter about Exhibit 5, is there anything you'd like to add about that? Mr. Kaplan, just what we added in our filing, that when it comes to Guideline 3.1, it says specifically that it's meant to govern this situation, and there's no equivalent thing with Exhibit 5. So, here, we know that 3.1 applies to this situation. There's no basis for the court to find, absent an evidentiary hearing, that Exhibit 5 would do the same. The court. All right. So now getting to, I think, the meat of the question about a hearing, a need for a hearing, and this is the first argument that I identified. So you're up again, Mr. Kaplan. So just stay on your feet. So I have a number of questions. Exhibit 6, which contains General Order the 3rd of January 2010 of the Altoona Police Department. I'm just turning to it now says, and I'm going to quote from the government, a documented, itemized inventory of all items taken from the detainee must be completed at the time of booking. Here's the difficulty I'm having, based on the factual record recited by both the government and the defendant and my own review of the body-worn camera footage from the McDonald's restaurant. It seems to me that it is undisputed that the backpack was next to Mr. Mangione while he was sitting down at a table in the public seating area of the McDonald's. Am I correct so far? That's undisputed, right? Mr. Kaplan, it was next to him at the beginning. At one point it was. Yes. The court. Yes. Second step, I think it's undisputed that officers initially moved during the initial conversation. Police officers moved the backpack out of Mr. Mangone's immediate reach to a nearby table. Am I correct? That's an undisputed fact, right? Mr. Kaplan, that is correct. The court. Okay. Third step, during the course of this initial encounter, the officers asked Mr. Mangione if the backpack was his, and he said yes, it was. Correct. Mr. Kaplan, that's correct. The court. This encounter ultimately culminates roughly 15 to 20 minutes later with Mr. Mangone's detention and arrest. The backpack, additional clothing that was removed from him as well are all taken to the police station. Correct. Mr. Kaplan, correct. The court. So given those undisputed facts, and I should just ask, Ms. Messiter, does the government agree with the factual recitation I've set forth? Ms. Messiter, yes, Your Honor. The court. So I'm a little bit confused by the argument in your January 6th letter that the backpack isn't clearly within the category of all items taken from the detainee, because the backpack is clearly his person property, right? No one disputes that. He said it was his. It's with him when he's arrested in a public place. The police took it from his custody and control in a single course of conduct that culminated in his arrest. He's being detained and then arrested, and the police have to safeguard his personal property. So what am I missing from that? My recitation of these events. What is disputed? Mr. Kaplan, yes. So two things, two areas, which I think the court needs to focus on. The court's been citing the 3rd of January 2010 of the general orders. If you look at 3.1.9, which is right before it, it's talking specifically about searches of the defendant's person, a detainee's person. They're clearly not talking about other property, backpacks or anything, referring to the court, but it's in a separate section of the orders talking about what happens when the prisoner is in the police station. The defendant, yes, but that's the second point I'm making, which is at the state suppression hearing, when this issue came up and we asked officers about this. Their testimony was that the 3rd of January 2010 would cover anything that he had on him or all that he had at the time of his arrest. It is our position that, at the time of his arrest, the backpack had been moved 10 feet away. There had been a number of officers in between then. He did not have custody or control of the backpack. And if the court's going to read from the defendant to be so broad, well, what's stopping them from going into his car? It belongs to the defendant also, so it's from the defendant. So I'm trying to limit the court. I don't think that's right, Mr. Kaplan, because, I mean, he's being removed from a public place. What if he has a wallet with credit cards and hundreds of dollars in cash sitting on the table at the McDonald's, and while the police are talking to him, they move everything they haven't searched away from his immediate grab area, which they're entitled to do for their own safety and public safety? Are they supposed to leave the wallet? They can't take the wallet. Or what about car keys or house keys or a cell phone that's sitting on a park bench next to a person who's about to be arrested? I take your argument that they can't then. If a defendant is arrested in his home, in a secured area, the police are not permitted to just take anything they see. They can't, like, go into a locked car and say, well, this is his property that's near him at the time of arrest. But I don't think it's really disputed that if you're arrested in a public place, the police are supposed to safeguard your personal property. So I guess I'm just not even looking at the testimony that you cited from the state hearing. The quote that's in that letter, I'm quoting from page 2 of your January 6th letter. Sergeant John Burns of the Altoona Police Department testified that this order pertained to inventorying property that was taken from the detainee's person and any property that he had with him at the time of being detained or arrested. And just in terms of ordinary English, I just am not following the argument that the backpack is not personal property that he had with him at the time of being detained or arrested, Mr. Kaplan. So I'm making the distinction between personal property that he has on him versus personal property that was no longer on him. It was in a different area, different section over here. It's not as simple as it was on the table in front of him. This was 10 feet away at the time of his arrest. If the Altoona parole guard wanted to say specifically that they can go into backpacks and stuff, they could have said that. The court, it's not about going into the backpack. It's about taking the backpack to the police station so that an inventory search can be done. Let's not talk right now about whatever they did with the backpack in the McDonald's. That's a separate issue. The question is this general order, which relates to inventory searches, that happens once they have the backpack in the police station. So as to that question, it's his personal property in a public place that is with him at the time he's approached by police. No one else can take custody of it. He's by himself. And the police have to. I mean, the difficulty I'm having, being sort of quite experienced with what happens when someone is arrested, is I don't understand the argument that there has to be some additional proof before they can safeguard, when a defendant is being arrested in a public place, the valuable personal property that he says is his, a wallet, a cell phone, a bag, a purse, keys, and just in the ordinary English meaning of property that is with him at the time of his detention or arrest. What would a hearing? What might come out of a hearing that would change that analysis? Mr. Kaplan, yes, based on just the reading of the patrol guide, the court is right. It may give them the opportunity to safeguard the property, but in order to go ahead and inventory and actually go through the property, I think that what the 3rd of January 2010 is talking about is not property that was not on the defendant. And I would agree with the court. They would be allowed to safeguard it. They can take it. But I'm saying that I don't think under the 3rd of January 2010 that would allow them to actually inventory and go through it. I think there are two separate issues. Can they safeguard it? Yes. Can they actually go through it as part of inventory? That's not what the 3rd of January 2010 is doing. And the purpose of the hearing would be to have actual testimony. We don't have to guess. We don't have to speculate. We would have actual testimony from people in the Altoona Police Department as to what their general understanding is about these guidelines and whether or not these guidelines would apply in this sort of situation. And to the extent that there was a state court hearing in which this came up, it's not the same as the court conducting its own hearing and viewing actual witnesses. The court, no, I understand, but it was your letter that pointed me to the testimony. So I'm just following up about what I think the plain meaning of the testimony is if I'm to rely on it at all. Mr. Kaplan, I put it out there so the court would know what the purpose of a hearing would be. We have testimony about this at a hearing on this. We would have actual testimony from an officer in front of Your Honor discussing these issues and the parameters of their answering of the 1st of March 2010. The court, okay, understood. Thank you, Mr. Kaplan. Ms. Messiter, anything you'd like to say about that? Ms. Messiter, no, Your Honor. In our view, the policy is clear on its face. The documented itemized inventory of all items taken from the detainee must be completed. It's of no moment that a preceding section deals separately with searches of the person of the detainee. That's not what we are relying on here, and we certainly agree that the arguments presented by the defense here would lead to absurd results by which either the police officers would have to leave the property of arrestees wherever they happened to find it at the time the person was arrested, or the property is somehow no longer the defendant's property and therefore is, I suppose, abandoned, in which case these arguments don't really arise anyway. So we think that this policy is clear on its face and there is no hearing that's needed in this regard. The court, all right, thank you both very much. At present, I don't think a hearing is necessary. I want to give some additional thought to the arguments that the defendant has made today, and so if, upon reflection, I change my view, I'll let you know promptly, and we'll schedule that within the next couple of weeks. All right, so turning to our main task today, which is to hear argument on the defendant's motion to dismiss counts 3 and 4, I understand, Ms. Friedman Anafilo, that Mr. Patel is going to be making that argument for the defendant. Ms. Friedman Anafilo, yes, Your Honor. Thank you for accepting our pro hac vice motion on behalf of Mr. Patel. The court, I'm happy to do that. Mr. Patel, welcome. We're happy to have you here as a guest from Maryland. Given the length of time, I think it would make more sense for you to speak from the lectern, if that's all right. Mr. Patel, that would be great. Thanks, Your Honor. The court, I've allotted 30 minutes to each side for this argument, and since it's your motion, Mr. Patel, would you like to reserve any time for rebuttal? Mr. Patel, yes, Your Honor. Can I reserve 4 minutes for rebuttal, please? The court, just for everyone's planning and for the sake of the court reporters, my expectation will be that we'll take a brief break after Mr. Patel's argument before the government argues, in case anyone needs a break and to give our court reporters a brief rest. Just before you start, Mr. Patel, I want to tell you, in fairness, that you can use your time however you want. You should expect me to interrupt you a lot because I have many questions, but I just want to advise you, don't spend much time on the divisibility of the statute between, Mr. Patel. I understand, Your Honor. The court, subpart A and B of parts 1 and 2. Again, I'm happy to hear you, and you can use your time however you want. But it's only fair to tell you that I think it's pretty clear that the statute is divisible and into at least those 4 crimes. So subpart part 1 into subparts A and B, part 2 into subparts A and B. But, again, I'm happy to let you try to convince me otherwise, but I want you to use your time in the way that would be most helpful to you and to the court. So that's my just starting advice, not to spend a lot of your time on that issue. Mr. Patel, thank you, Your Honor, and that wasn't my plan today. I think that there's 3 arguments that we've made, and the first one is about the divisibility. So each statute is indivisible and has at least one means, the emotional distress subsection, that never qualifies. That's the first point. The court, and I think the government doesn't, at least as to whether subpart B of either part would qualify. I don't think the government, I understand the government to be conceding that the substantial emotional distress way of committing this crime would not qualify, so I think that's one place of agreement. Mr. Patel, that's my understanding. Okay, yes, where I want to spend my time, Your Honor, is on this second argument that, even if the stalking statutes are divisible between subsection B, the emotional distress subsection, and subsection A, the reasonable fear of injury subsection, that's what I'm going to call it. There's so many words here, it still fails to qualify as a crime of violence because it can be committed by a threat of self-harm, that is, by the defendant threatening force against himself. And then the third argument is that subsection A fails to qualify as a crime of violence because it does not require the purposeful or knowing threat of force. But, again, like I said, Your Honor, what I want to really focus on today is that second argument on the threat of self-harm, because I think that's the easiest way, that's the cleanest way, for the court to give relief to Mr. Mangione today, because that argument is supported by the plain language of the statute, directly on point authority, United States versus Plunkett, and there are no cases to the contrary that exist. So, Your Honor, I will start with that argument. So turning to that argument, the plain language of subsection A criminalizes the act of placing the stalking victim in fear of injury to a family member, to a spouse, or intimate partner of that stalking victim, which is referred to as that person in the statute, because family member, spouse, or intimate partner can be the defendant himself, Your Honor, this subsection A fails to qualify as a crime of violence under the force clause, which, as you know, requires threat of force against the person of another. Now, Your Honor, the two courts have agreed with us. We have United States versus Plunkett, which is the written decision, and then there's US versus Ali too, and the government referenced that. I looked it up yesterday. There's not a written decision yet, so we just have the oral decision right now, but my understanding is that the court is going to wholesale adopt the Plunkett analysis, and, again, I just want to repeat, there's no authority to the contrary. Now, Your Honor, you should join that chorus because in Plunkett I think this is really key. The court explained that it had no difficulty envisioning situations that could satisfy all the elements of interstate stalking, but not necessarily involve the use, attempted use, and threatened use of physical force against a person. Now, I understand in Plunkett one difference was there wasn't the death results factor, but that the court, let's put a pin in that, and we'll circle back to the death resulting question. Mr. Patel, yeah. But, Your Honor, what I wanted to say is that there are very plausible ways here in which this can happen, in which there can be a threat of self-harm. We've given some examples, and I don't think it changes with the death results, so I'm happy to give you more examples. The court, no, I think the examples are sort of self-evident. It's relatively easy to imagine, in a literal reading, in a domestic violence context, where an estranged spouse or partner or even a stranger, but I think more likely a stranger wouldn't be within your example, right? Because they need to be one of the proxy individuals identified in the Romanet subparts. Mr. Patel, absolutely. The court, so an estranged husband or partner who gets the victim to do what they want in the past and in the charged incident by threatening, I'll kill myself if you don't, I'll cut myself, I'll jump off this bridge, I'll crash this car right into the, abutment. So I don't think I need the examples. I think there's a couple of issues that I think would be helpful to address, and maybe we'll start with the death resulting issue, because I guess my first question is, do you agree that, as charged here, death resulting is an element of the offense that must be proven to a jury beyond a reasonable doubt? Mr. Patel, Your Honor, I am not disputing that. The court, okay, I didn't think you were, but it's always good to make sure. Mr. Patel, yeah, thank you. The court, so assuming yes, does that element charged here affect the crime of violence analysis, and if so, how should it affect my thinking? And if you could just talk a little bit about Ison Van Runyon and the views of those courts that, in talking about those predicate crimes, their conclusion was that death resulting made it impossible to commit the crime as charged without the use of violence. Mr. Patel, well, Your Honor, yes, I'm happy to talk about Ison Van Runyon. One thing to keep in mind, the landscape was very different when Runyon came out. Runyon relies on the realistic probability, right? Since then we have clear law, Taylor versus United States, which said we do no longer rely on realistic probability for federal offenses, and Elkins said that too. In fact, in Runyon too, the court said we can imagine a situation, right, where death would result, and that was, I believe, a conspiracy to murder for hire resulting in death, but they really hinged the opinion on the realistic probability, so I don't think that case is apposite here. The court, can I just press you a little bit, while we're talking about Taylor and realistic probability? Mr. Patel, yes. The court, would you agree with me that there's two ways to think about what the realistic probability test means in Taylor's context, right? One way is the kind of test that had grown up that is very clearly rejected in Taylor, which is the notion that a defendant has a burden to show that there's a realistic probability that his case, or some imagined hypothetical case, that there's a realistic probability that such a case would be charged and prosecuted, and kind of some empirical showing that that was a real danger that the court had to worry about. In Taylor, I agree with you. Taylor very clearly says that, absolutely not, no defendant is required to do that, and in fact, that's not even a relevant inquiry. I think the question that is maybe left unanswered by Taylor is whether realistic probability is viable still in the sense of where older statutes don't use the exact words of the crime of violence definition, that a court has to look at the words that are used and ask itself, do these words mean, given the laws of physics and the nature of human interaction, do these words mean that you couldn't do these words? It's a practical impossibility to do these words without using, attempting, or threatening to use violence. Mr. Patel, Your Honor, if it's an impossibility, I agree with you, but if it is plausible, If there's any way that it's plausible and it could be prosecuted, then the government loses. In fact, in Taylor itself, the court turned to hypotheticals. That's the way that we have to do the inquiry now, because, the government keeps saying, oh, far-fetched, this and that. Even if it's far-fetched, if it can happen, if it's plausible, that's why Taylor really changed the landscape. But I want to go back to Tsarnaev and then Runyon, too, because we have a very different situation, setting aside the realistic probability problem that they relied on that. In Runyon too, I believe there was an intent to murder because it was a conspiracy to murder for hire. Okay, and so that's why they really relied on that intent and said, when somebody's intending to murder somebody, we don't see a realistic probability that, even though the death results prong doesn't have a mens rea, that it could happen in a way where it's not intentional. And the same thing in Tsarnaev, right? The crime, forgetting exactly what it was, but it was the court placement of an incendiary device or IP document arson. Mr. Patel, yes. In fact, in Tsarnaev, they relied on that. That intent was really important because Tsarnaev also found that there was another offense that was reckless, right, that didn't have that intent, right. But here, Your Honor, the only intent is the intent to harass. So where do we get intentional murder from intent to harass? The court, right. Of course, the statute speaks of intent to kill, injure, harass, or intimidate. But I agree with you that, based on the case law, harass is kind of the least serious way of committing the crime. Mr. Patel, absolutely. The court, and that's what we have to focus on. Mr. Patel, yeah. So, Your Honor, getting to the death results part, I think here it's very plausible that death would result. If a defendant is putting a gun to his head, right, and he's out in public and let's say there's a drug-addicted brother who's demanding money from the victim, and then she's like, no, I'm not going to give you the money. I'm not going to give you the money. I'm not going to give you the money. And then he says, okay, I'm just going to kill myself because he's stressed out, he's mentally ill, he's addicted, he needs his drugs. She tries to wrestle the gun from him. That's very plausible and the gun misfires and it kills her. Or there's a first responder, there's a police officer around who sees that, and tries to take the gun away from him, and then it misfires and it hits a pedestrian. Or, Your Honor, we know these things happen. What happened in Minnesota recently, right? A police officer sometimes see things differently, and they may see the gun and they may try to shoot him, and then the sister gets in the way and gets shot. So it's really plausible here what we're talking about. The court, as I read Elkins being the most recent example, there seems to be a developing consensus that, at least for this statute, the death resulting there's no intentionality required in order for the government to convict a defendant on the death resulting enhancement, I'll call it. Mr. Patel, yes, there's no case the court, a jury does not have to find any intent or even purposeful action that produces that on the part of the defendant. It's just probable cause. Mr. Patel, and particularly in this situation where I think you agree with me that it's very plausible that this threat of self-harm, it happens. It's a very common occurrence as, the court, I agree with you, it happens. The question is whether that is intended to be covered by the statute. Yes, but I agree with you that it could happen. Mr. Patel, right. And if that could happen, then I think it's easy to get to the accidental death happening too. So, for that very reason, I think the Plunkett decision, combined with what I just talked about with death results, combined with the Ali decision, Your Honor, you don't need to tread new water here. It's already there for you. I think this is the cleanest way to give relief to Mr. Mangione. Now, what I'd like to talk about is some of the government's arguments. The court, yes, I was going to say I know the government's primary response falls into two categories, one meaning that the Romanet parts are divisible, and then the second meaning that reading the statute to apply to self-harm is unnatural and could result in criminalizing conduct that is not criminal. Mr. Patel, I will talk about all of that. So, first, Your Honor, I just want to say sometimes, when it benefits the government, they take another position. So in U.S. v. Garg that cited to in our brief, in the Western District of Washington, the government agreed to a jury instruction which clumped all of those terms together in a single element. So the way it went to the jury didn't have to be unanimous on either of those. And you know what, Your Honor, that benefits the government, right? Because if we have 6 jurors who believe that the crime happened, but it was with respect to a family member, and we have 6 jurors who think it was with respect to the stalking victim, right? And then they can't decide which one unanimously, but they all agree that a crime happened. Well, then the defendant gets to go free. That doesn't benefit the government. That doesn't benefit the stalkee. So that's just one thing to keep in mind about this concession. But, Your Honor, their change of heart here also has no legal support. The government cites to cases in which courts have held that statutes with very particular subsections were divisible, or they cite to cases where the different phrases were about varying substantive conduct, but we don't have any of that here. Your Honor, what we have are a bunch of terms, people, and it's all within one subsection. But more importantly, Your Honor, these terms all refer back to a singular victim, the stalking victim, right? This is all about the stalking victim. That's what we're trying to protect here. And the entire statute focuses on ways in which that person, the stalkee, is harmed when that person is put in reasonable fear of injury to his family, when that person is put in reasonable fear of injury to his spouse, when that person is put in reasonable fear of injury to his intimate partner. So, it's all going back to the stalking victim. And one thing I find very helpful here too, Your Honor, on A it says places that person in reasonable fear of the death of or serious bodily injury to, and then what do we have? An M dash. The M dash means that everything is going back to that, the stalking victim on A, because that's who this statute is trying to protect. It's not trying to protect the family member or the intimate. There's different statutes for that, but even more compelling, Your Honor, is, I was looking at the definitions yesterday of spouse, and I was looking at the definitions of immediate family member. Well, guess what? They overlap because spouse includes the word spouse, and then you go to the immediate family member of an individual, and it includes spouse again. So it's not even differing conduct, and that's a very telling sign that we have an indivisible offense here. Additionally, Your Honor, when, I think that B helps us here too, Section B, because the Section B clumps them all together in one sentence, right? That's indicative of alternative means. And then they refer back to A, so it can't be that one subsection has alternative means and one has alternative elements. That wouldn't make any sense. So I think, when we look at all of that, it's really helpful. But in addition to that, Your Honor, also, I think the legislative or the statutory history also helps us here, because in 2018 Congress added the pet service animal, emotional support animal language. They didn't do that to protect the animal. Again, that was emphasizing the singular nature, like to protect the stalking victim. Because what Congress said is because victims of domestic violence often may be reluctant to leave an abusive relationship out of fear for the safety and welfare of their companion animals. The court, I think the idea is that the categories represent people that are, in essence, proxies for the targeted victim, a way to get to the targeted victim through some proxy person, their child, their new partner, a beloved pet, Mr. Patel, but like you just said, they're a proxy for who? For the victim. That's what this statute's about. And if we're trying to protect the victim, then what do we want? We want them to be alternative means. So if a jury is in conflict about which way this happened, then the jury can still convict so that a defendant doesn't go free, Your Honor. So, actually, it would help them in this case if they had alternative elements and not alternative means. The court, so talk a little bit, Mr. Patel, about the government's second argument that the reading that would include self-harm is counter to the purpose of the statute and an unnatural reading of the statute as a whole, and also risks criminalizing conduct that is innocent or is not criminal. Mr. Patel, right, Your Honor, so I think it's going to look at Ellenis versus United States, right? That case was very different because in that case, and they wrote a 28, I don't know what you guys call it here, sorry, the court, a supplemental letter. I did read it yesterday. Mr. Patel, this is not appellate court, but anyways, I think, so, let me talk a little bit about Ellenis first. Ellenis was the case where at issue was the threat statute under 18 U.S.C. 875. There was no center at all, like no nothing. And so the court said that to make sure that we're not criminalizing innocent conduct, we have to read a mens rea into it, right? But as a Flory court said, the 11th Circuit said, we don't have that problem here because we have an intent to harass, and you travel in interstate commerce with an intent to harass. So there's already criminal conduct here. You're not criminalizing innocent conduct. Also, Your Honor, if somebody's putting a gun to his head and saying, like, if you don't give me money, I'm going to kill myself, or, if you don't give me drugs, I'm going to kill myself. You're manipulating the victim. There's still somebody being victimized. That's not innocent behavior. That is criminal behavior. So, Your Honor, the innocent, I don't get her argument in the context of this statute. The court, what about the government's argument about the purpose of the statute is not intended, essentially, to give protected status to a defendant engaged in this activity, and it's intended to protect victims. Mr. Patel, well, Your Honor, the court, there's sort of unnatural reading argument. Mr. Patel, right, Your Honor, but, again, here it is to protect the victim because it's often the case that the victim is being victimized by a relative, right? And that's what Plunkett was talking about. So if it's to protect the stalkee, right, the person being victimized, then this should be included in there because there's lots of situations where you have a family member that's going to manipulate the person being stalked. So it's not an unnatural reading at all. And, Your Honor, in order to say that an interpretation is absurd, it has to shock the conscience. It doesn't shock the conscience here because you're trying to protect the person being victimized, and the person being victimized, that can happen with a family member, with spouse, with an intimate partner. So there's nothing strange about reading a threat of self-harm into this statute. It exists and it should exist because the ultimate goal here is to protect the victim, the stalking victim. The court, well, unless there's something else you want to say about self-harm, Mr. Patel, I think we should move on to talk about Mr. Patel, mens rea. The court, the mens rea argument. Mr. Patel, yes, the court. I guess my sort of starting question is there a way for a defendant to cause reasonable fear of serious bodily injury or death that doesn't involve at least the implicit threat of physical force? Mr. Patel, so can I give you an example, a better one than we gave in our brief? So imagine a brother travels from New Jersey to hike with his sister in a New York state park. So that's the interstate travel part, right, intending to harass her for his money for the drug habit. He's addicted to drugs. He needs drugs, so he's like, okay, I'm going to go on this hike with my sister, and I'm going to harass her when I'm there on this mountain cliff. And he does so while they're on a narrow precipice of the steep cliff, screaming, gesticulating wildly because he's upset that she's not going to give him the money. Now, she reasonably fears for her own death or serious injury because he's, but he doesn't want to harm his sister, and he doesn't think he's doing anything to put her in fear of injury, right? But she feels, because sometimes, Your Honor, there's divergence of views, right, between the victim and the person being victimized. So that can happen. So that's a situation that could happen, and then she gets distracted and falls off the cliff and dies. So then there's death resulting from that situation where all the elements of subsection A are met and the death results provision, because the brother traveled in interstate commerce with an intent to harass the victim and, in the course of the travel, engaged in conduct that placed the victim in reasonable fear of injury and death resulted. But you have an accidental death, and you don't have an intentional or knowing threat of force. So that's an example. The court, I think I'm very familiar with the Flory decision in which applying to subsection B, but focused on this part about what does a defendant have to do to cause the result, whether it's substantial emotional distress or fear of injury. So understanding that the Flory court has said that, essentially, no mens rea is required, the government does not have to ask a jury to find beyond a reasonable doubt any level of intent related to the cause that effect, but in the government's brief, they argue that, even after Borden, the kind of traditional criminal law concept that criminal statutes should be read to presume at least a mens rea of knowledge. What is your response to that argument? How should I be thinking about that question, Mr. Patel? So I think, again, we have to go back to Elenis, right? And I think Flory addressed this. So if you have a situation where there's no mens rea, right, then you may have to add an additional mens rea. But that's not the problem here because we do have an intent to harass. So I think there is no additional mens rea that needs to be added here to separate wrongful behavior from innocent conduct. The court. So let's talk about these other district court cases, Mr. Patel, because recognizing that they have go ahead Mr. Patel. Oh, I'm sorry. I wanted to talk the court, before we go to that, Mr. Patel, also about, I think this is so compelling when we look at the statutory history, because Congress knew how to write an intent element into or an intent element, or intent mens rea into the reasonable fear of injury prong, and they did right beforehand, and then they took it out. That is really compelling evidence that they didn't want it in there anymore, and that makes sense because they want to make the statute as broad as possible to protect the stalking victim. So I think that is really, really compelling evidence. I'm sorry I interrupted you. The court. No, that's okay. Like I said, I have many questions, but I also want to make sure that you have time to make the points you want to make. Mr. Patel. Yes. The court. But just recognizing the views of other district courts and, certainly, magistrate judge opinions from other districts are not binding on me in any way. Mr. Patel. Absolutely. The court. But it nonetheless is the case, as far as I can tell, that there are at least 4 district court decisions from other circuits that have looked at this statute and said it is a crime of violence. And that would include Johnson, Ali Ibeth from Southern District of Florida, the Bacon case from Delaware, and Griffin from Eastern District of Michigan. And if you could just kind of walk me through, Mr. Patel, to the extent you haven't already addressed it, why you think I should reject the reasoning of those cases. Mr. Patel. Yes, I think all of those cases are deeply flawed for several reasons. So, Your Honor, these cases don't use the word realistic probability, but that's what they're doing. They use the word legal imagination. Where does that come from? That comes from Dunas Alvarez, which is all about realistic probability. So maybe they're not using the words realistic probability, but that's, in effect, what they're doing. So that's one problem with these cases. In the Griffin case, too, also it was a very strange analysis. They just said, oh, anytime death results, like, that just means that now there's going to be it changes everything, without even explaining it. I think they cited Turtsanev, right? Maybe, but there really was no other explanation. But I think I've given you an example where death can result in this situation. So the court, let's talk about Bacon, because I think the analysis in Bacon, the Delaware opinion, is arguably the most thoughtful. And the court in Bacon says, on this question I asked a little while ago, whether, when you put all of these things together, is at least the threat of force implicit in all parts of the statute put together. And the Bacon court says, well, if you intentionally set out to kill, injure, harass or intimidate, then you do things that, in fact, have the effect of creating reasonable fear of serious bodily injury or death. That all of those things put together must necessarily involve at least a threatened use of physical force. And what's your response to that analysis, Mr. Patel? So I gave you the hypothetical. I think that there can be a divergence. So the way I look at it is intent to harass. That's where you look at the defendant's perspective, right? And then you look at reasonable fear of injury. That's from the victim's perspective, right? So that situation where you have the brother gesticulating, like angry because he's not getting the money from his sister, but he loves his sister. He doesn't think that he's doing anything to harm. He would never harm his sister. And so in that mindset he can't imagine a situation where he's putting his sister in reasonable fear of injury. The court, and the argument is that if a case of your hypothetical went to trial, your argument is that the government would want a jury instruction or be entitled to a jury instruction that says all you need to find is that the victim objectively had a reasonable fear of serious injury. Mr. Patel. Absolutely. That's what they'd be asking for. The court. The government is not required to prove that the defendant knew or intended to cause that result. Mr. Patel. Right. The court. Okay, Mr. Patel. Exactly, Your Honor. Does the court have the one thing I wanted to address, too? The government says, this Miners case is garbage. That was different language. I think that's really exaggerating how different the statute was at that time, because the statute at that time didn't have the engaging in conducting language. So you just had to travel, and, in the course of the travel, you placed somebody in reasonable fear of injury, whereas now there's the engaging in conduct that places somebody in reasonable fear of injury. But I don't think that changes the analysis because, like the example I gave you, yes, the brother's engaging in conduct like, he's gesticulating, he's whatever, and that happens to place the victim in reasonable fear of injury. So I just think that the Miners case, I agree, I don't think the hypotheticals were the best there. I think I've given you better ones than that, but there is a court that has recognized that this can happen. So I think one thing, too, in some of these cases, the bad cases, I call them, there's not this, they haven't considered the hypothetical that I gave you. I don't even know if that was put before them. And the other thing is in those cases, they didn't look at the statutory history that we've given you. They didn't look at the Flory decision, right, which, by the way, the Second Circuit has approvingly cited too. The court, right, although I looked at that, Mr. Patel, I know it's a bit different. The court, the citation is not quite for the point that I think is really the heart of our issue here, but I know I have kept you over your time, Mr. Patel, but I just have a couple of other questions that I want to ask you. There are other criminal statutes that use similar language about fear of injury, and I think, most notably, Hobbs Act robbery. One of the ways you can accomplish a robbery is by creating a fear of injury, which is very similar language to what we have here, and the courts have consistently held that a completed Hobbs Act robbery, even if accomplished by fear of injury, is a crime of violence. And so why is this statute and the language here that talks about reasonable fear of injury, why should I view that differently than courts have viewed that language in the Hobbs Act, Mr. Patel? So, Your Honor, in those cases, I think there's intimidation, I believe, is the language that's used. Also, I think those cases are different where you're talking about robbery where you have an intent to harass, right, and then happens to place somebody in reasonable fear of injury. Actually, there's two cases I wanted to talk about that where you have this reasonable fear of injury language. It's almost identical to what we have. It was in the Carter case. This was a Georgia assault statute, and then the Garner case from the Fifth Circuit. It was also a Louisiana statute, and the exact language we're talking about, the reasonable fear of injury, was in those cases, in those statutes, and the court said, 100K, all that requires is that the defendant intentionally engaged in the act that happens to put somebody in fear of injury. The court, I apologize, Mr. Patel, I'm not expecting you to track the Second Circuit's summary orders, but there was a summary order this fall, in September, in a case called U.S. v. Williams. The defendant, the court, addressing the Vermont simple assault statute which also uses the fear of imminent serious bodily injury language. Now, that statute, the full language is attempt by physical menace to put another in fear of imminent serious bodily injury. Mr. Patel, by physical menace, I think, makes that different. I'm not familiar with that case, but also, Your Honor, I think you have to keep in mind again, we have to go back to the statutory history, which we don't have this with the Hobbs Act robbery, where Congress contemplated the intent language. They put it in there, intent to place somebody, and then they took it out. That, to me, is really powerful. It has to be. The court, all right, we've gone over your time, Mr. Patel, but I'm still going to give you your 4 minutes on rebuttal. Mr. Patel, thank you. The court, anything else you'd like to say before we take a break? Mr. Patel, no, that's it. Thank you. The court, all right, thank you very much. All right, so it's 12:20. We'll just take a 10-minute break. We'll resume at 12:30 with the government's arguments. Thank you. Recess. The court, you can all be seated. Thank you. Okay, Mr. Gentile. Mr. Gentile, Your Honor, as you can see, the prosecution team has divided its responsibilities. Mr. Zhang is going to handle the crime of violence argument. The court, okay, great. Mr. Zhang, you want to use the lectern? Mr. Zhang, yes, Your Honor. The court, so I'll just begin. Mr. Zhang, I think the great difficulty for the government is that the statute is written, it seems to me, intentionally as broadly as possible to cover a wide range of conduct, and that's a very understandable and laudable goal of Congress, given the history of domestic violence in this country, in that prior to some of these statutes, there was essentially a world in which a woman could go to the police and say, "He is calling me at all hours of the day and night, he's sending flowers, unwanted things, to my work, to my home. When I come out of the grocery store, I see that his car is there and follows me home, and you've got to do something." And the typical police response would be that, well, there isn't anything we can do, right? If he actually tries to hurt you, you can get a restraining order, and if he actually tries to hurt you or get inside the house, then you should call 911, and then we'll do something. But until he actually tries to hurt you, there's nothing we can do, and to a significant degree, I think, the statutes that are at issue here were designed and have been revised multiple times over the years to try to create a remedy and a law enforcement option before anyone is actually hurt or dead, right? And that goal and that statutory design, if I'm right, is really in a lot of tension with what the Supreme Court is telling me I have to do to conclude that this crime can be a predicate for a 924C. So I guess, first, I'll invite you to tell me why I'm wrong about that kind of framing. if there's something you want to say particularly about that, and then we can start from there wherever you'd like to start. Mr. Zhang: Sure, Your Honor. So I would certainly agree with the first part of Your Honor's framing as to the purposes of the statute and its revisions over time, and I would agree with Your Honor that the sort of scenario that Your Honor described about, well, I'm receiving all of these threats or communications that I perceive to be threatening, and the police saying, well, he hasn't followed through on them, therefore, we can't do anything. That's something that the statute is intended to address. However, I would say, sticking with that just core or heartland scenario for a second, that comes within the Elements Clause, right? Because, keep in mind, the Elements Clause is not solely about the actual use of force, it is also about the attempted or threatened use of force. And as we've argued and as the Supreme Court made clear in Borden, it need not even be about the intentional or purposeful threatened, attempted, or actual use of force. It would be sufficient if there is the knowing, right? Knowing but not purposeful, attempted, threatened, or actual use of force. And so I would say that, actually, the fact that the statute wants to cover those scenarios is not in tension with the notion that it categorically fall under a crime of violence. But I think the other point I want to make here real quick, Your Honor, is that even though the statute has been, of course, broadened, the government's position is not all aspects of the statute are crimes of violence. As Your Honor pointed out, there is no dispute between the parties that what we call the emotional distress subsections of the statute are not crimes of violence. And I would say that part of the broadening of the statute is to cover that aspect, right, where the conduct by the stalker does not rise to the level of someone reasonably fearing I'm about to die or suffer serious bodily injury. Something less than that is what that was intended to cover. And I think, as the court suggested early on, and there wasn't much argument because it seems like we're all seeing where this is headed, those parts of the statute are, at a minimum, divisible. So I think that would be my response to Your Honor's thematic point. The court, before we move on, just very briefly on divisibility, what is your response to the defense argument that you should be bound by concessions that the government may have made in Plunkett, the case in the Western District of Virginia, or in Garg, the case in the Western District of Washington, about divisibility? Mr. Zhang: We don't agree. Individual positions taken by individual AUSAs in other districts do not bind our office, do not bind this prosecution. There's no indication that those positions reflected any sort of considered opinion by, for example, the Solicitor General or the Criminal Appellate Division. And as Your Honor knows from looking at those submissions, one of those, the one in Plunkett, was a response to a 2255 in which the AUSA basically said, with no analysis at all or engaging with any of the relevant statutes or any of the relevant authority, it appears the statute is not divisible. And the one in Gargas, it was a jury instructions issue, and I think later on it was a footnote in the context of a sentencing submission about restitution, and the divisibility issue came up in the context of that footnote. So, needless to say, in neither of those cases was the issue sort of teed up in quite the way it is here, and in any event, it does not bind the government in this prosecution. The court: Okay, well, I mean, I have my order of questions, but I don't know, I don't want to control things too much, Mr. Zhang, from what you'd like to talk about. But just to stay kind of in the order that I was focusing on with Mr. Patel, just to close off a few things that I think aren't disputed, right? I know the government has argued that death resulting is an element of the offense that must be proven to a jury beyond a reasonable doubt. That's right, correct, Mr. Zhang, that's correct, Your Honor. The court: And assuming that, what's the government's view about how a case that has charged death resulting as an element, what weight should I give to that? What role should I give to that charge in assessing whether the predicate crime is a crime of violence? Mr. Zhang: So the government's position is this: we are not making the argument, Judge, look at this element. This is the thing that satisfies the Elements Clause. We're not making that argument. What we are saying is what the cases invite the court to do in categorical analysis is to look at the minimum conduct necessary to satisfy all of the elements, and under Mathis, a penalty-enhancing provision like 2261, b(1), counts as an element. And so what we're saying is, in considering whether the other elements require the government to prove the actual threatened or attempted use of force, it's further constrained by the fact that, as charged here, there's this additional death resulting element, that is, as we are thinking through about the plausibility of or whether these hypos work or don't work, these hypos must necessarily include some story about the death resulting because that's something that the government's going to need to prove anyway, the court. And, again, just in terms of trying to narrow what is in dispute, do you agree that, at least for this statute, the death that results need not have been intended by the defendant? It can be an accident or something that arises from reckless conduct. Mr. Zhang, we agree with that, Your Honor. The court. All right, I thought so, but I'm just trying to close things down. So maybe, if it's all right with you, Mr. Zhang, let's start with the defense argument about self-harm. Mr. Zhang, sure. And if it's all right with the court, I'd first like to start with what I'll call the Romanet divisibility argument. The court, sure. Mr. Zhang, look, I think our argument that the Romanets are divisible largely tracks our arguments in the case law for why the reasonable fear of death and bodily injury subsection is divisible from the emotional distress, which is, what the Second Circuit is largely said in these types of cases is, look, it's not really dispositive, but if it's a disjunctive list, and if the items on that disjunctive list are separately enumerated, meaning with letters or romanets or whatever, that's a very strong signal that Congress intended these to be elements rather than means. And I think the primary response from the defense to date has been, no, they're means rather than elements because they're intended to achieve kind of a common statutory purpose, right? The protection of victims. The court, I mean, in order for something to be divisible, one of the tests for divisibility is to ask whether you could be separately charged in the same indictment with multiple crimes based on a separation between whatever the thing is that we're asking, if it's divisible. And I think that the government is on pretty firm ground, as I said at the outset with Mr. Patel, with regard to subpart parts 1 and 2, and within those subparts A and B, because on that question, do you have a multiplicity or double jeopardy argument, courts have been uniform, as far as I can tell, in saying, no, you can be charged in the same instrument with multiple crimes for the same course of conduct as to those 4 parts. But I have a somewhat greater difficulty imagining, let's take a scenario where the threat at issue or the defendant's conduct at issue is a threat to, like, I swear I'll burn down this house, and I don't care if I kill everyone inside. And inside the house is the estranged romantic partner, maybe her new partner, and a child or the family pet. It's difficult for me to imagine that that scenario is then chargeable in 3 separate counts as 3 different crimes because that threat does, I think, would place the former partner in reasonable fear of serious bodily injury or death to herself, to the new partner who she knows is also in the house, and to the dog. And so what's your response on that? If a threat or course of conduct is directed at multiple people that are in these enumerated categories, to think that that is chargeable as separate crimes for each person who the victim might fear is at risk of injury or death. Mr. Zhang, so Your Honor is right that the natural consequence of the government's position here is that the Romanets are chargeable as separate counts, and that if they were charged in a single count, that count would be multiplicitous. I think on the hypo that Your Honor mentioned, I think the government has a different intuition, which is actually those would be chargeable separately, and the same way, for example, that in the context, say, of a gang shooting, right, where someone sprays a whole bunch of gunfire and 3 people are killed, it is not only common practice but legally necessary that each of those murders be charged separately, even though it's a single course of conduct. And I would say that, if that house burning scenario were charged separately, the government's burden would be different, right? Because the other aspect of the government's argument, and this goes to the mens rea point a little bit, is that there needs to be the statute should fairly be read that the defendant at least knows or intends that the defendant be placed in reasonable apprehension, so as to the different occupants of the home, the court, right? We'll get to that issue because I think that's fairly in dispute. But I think your intuition is correct in the sense, like take the Elkins case, right, where the issue there was a defendant had targeted for harassment both a long ago romantic partner, if I'm remembering correctly, like a girl he had briefly dated in high school. They are now adults and her husband, and both of them were the target of the harassment, right? And the Elkins court, the Fifth Circuit, says the unit of prosecution is the intended victim of the harassment or intimidation. And in that case both the woman and her husband, like multiple counts, were charged with both the woman and her husband identified as the targeted victim. So I agree with you as to that it's possible, where the harassment is intentionally directed at multiple people such that each of those people falls into that person definition, that's the unit of prosecution, and they could be charged in multiple counts. I think the difficulty is on the divisibility question, imagining a situation where there's only one that person. There's the targeted victim of the harassment or intimidation, and then the question is the last element can be satisfied if that victim reasonably fears, bodily injury to herself or any one of a list of other people. And that seems to me a little bit different than a situation like Elkins where the defendant is intentionally targeting his harassing or intimidating behavior at more than one person and each of those people then qualifies as a person who can be an identified victim. Does that make sense? Are you following me, Mr. Zhang? Does it make sense what I'm asking, Mr. Zhang? I think so, Your Honor. Let me respond in a couple ways. The court. Okay, Mr. Zhang. First, this is, I think, pretty clear. This degree of divisibility, the argument that the government is advancing, the government recognizes is not really an argument that has been teed up in this way before, and so it's not surprising that, say, in jury instructions in other prosecutions that this granularity or slicing the onion this fine hasn't been done before. So if it wasn't in Elkins, I think that's probably why it wasn't. But if Your Honor's concern is, well, what if there's just a single unitary conduct that occurs, but it has ramifications for reasonable apprehension as to different of the categories? I guess the government's response to that is, well, that's not unusual in criminal statutes. And returning to the gang example, I'm just familiar with gang examples. Say this is a gang hit against the intended occupant of a house, right, or a residence. And so what they're trying to do is they're trying to kill that person, and they toss a grenade in, right, and the thing blows up and it kills 3 or 4 other people. We wouldn't say, well, the unit of prosecution is the tossing of the grenade. The unit of the prosecution are the people who get harmed by it. And I think just to go back to, I think there is a connection between this point and the mens rea point. The court. I was just going to ask you that question, Mr. Zhang. Some of this analysis, right, I wouldn't say turns on, but is influenced by this other question that we kind of put to the side for the moment about what is the mens rea that the government's required to prove for this cause reasonable fear of serious bodily injury. Mr. Zhang. Right. So the government's answer to that, just to preview that part of the argument, is that the defendant needs to know that his conduct will place the interstate stalking victim in reasonable fear of death or serious bodily injury to those various enumerated categories, and so as to his knowledge of the reasonableness of the fear as to any specific category, that is a different element on which the government bears the burden of proving beyond a reasonable doubt, and therefore, those are separate crimes under the Mathis analysis. The court. How do you square that argument with the 11th Circuit ruling in Flory in which they said very explicitly again, it was at the substantial emotional distress prong, but it's the same statutory structure, right? The subparts A and B are about the effect that your behavior produces in a victim, and in Flory the 11th Circuit says quite clearly there a different kind of argument was advanced, right, not accidental. But the defendant had a cognitive impairment such that the defense wanted the jury instructed that the defendant had to intend or at least know, have purposeful awareness, knowledge, that what he was doing would cause substantial emotional distress, and the 11th Circuit said no, for the relationship between the defendant's actions and the effect that makes out the last element, the government is not required to prove even knowledge. If they've proved intent to harass, intimidate, kill, or injure, the travel or interstate communications and a course of conduct, then it is enough that we then turn to the effect on the victim with no mens rea required for that element. Mr. Zhang. So, look, Your Honor, we recognize there's some tension between what Flory says and our position. What I will say is there's other legal kind of layers in Flory that influence that analysis that are not present here, right? That was a case about a threat, right? True threats and the First Amendment, and that aspect of the analysis. I believe what the court said there is, look, part of what we're not interested in doing is displacing the specific intent that's enumerated by statute with the kind of true threat type language. The court, right, a desire to try to create a distinction between the place where the true threats analysis is supposed to be applied and then the rest of the statute. Mr. Zhang. Correct, Your Honor. Look, at bottom, what Flory is, right, is simply a decision about the adequacy of the jury instructions. I mean, at a certain level, that's what that aspect of the decision was about. And I think on this footnote 8 of that decision is instructive because, and I'll just read it very quickly, the 11th Circuit says, notably, the court's jury charge defining the subjective intent to harass or intimidate required the specific intent for purpose of causing an adverse reaction in a specific person, or of putting a person in fear or apprehension of injury inflicted by a particular person. Thus, in addition to the requirement that the content of the message had to be a true threat, the court charged that Flory must have had the specific intent to cause an adverse emotional reaction or to cause fear. Now, obviously, Flory was about the emotional distress subsection, so we can kind of strike or ignore that language, but if one strikes that language and says, look, part of why we're comfortable with this is because the district court, the trial court, in fact, charged that Flory must have had the specific intent to cause fear. Well, that's not their argument, right? Their argument is the reasonable apprehension piece is basically strict liability. They're basically saying, look, as long as there's interstate travel and subsequent to the interstate travel there's conduct, the foreseeability that that conduct would cause reasonable apprehension or fear in a victim of death or serious bodily injury, that doesn't matter. Even if that were completely unforeseeable, you'd be on the hook under 2261A, and the government's view is that's just not a natural reading of the statute. The court, let me give you a hypothetical. Let's say I'm the estranged spouse of a woman, and I've been trying to guilt her to talk to me about some aspect of our divorce proceedings, the alimony, whether we ought to, whether she will withdraw certain allegations against me. And I've tried, I've emailed, I'm calling, maybe to an extreme, and she doesn't respond and won't talk to me. So one day I drive my car to the public street where her house is, and I park my car on the public street. So I'm not on her property but entirely blocking the driveway, and I'm texting, like, I'm sitting out here, and I'm staying here until you agree to talk to me about this issue. Let's say my prior communications have been sufficient to amount to intent to harass. Unbeknownst to me, inside the house is my former wife's child who has severe asthma, and the stress of the situation prompts an asthma attack in the child, and my estranged wife now does, because of my actions, reasonably fear that the child might be seriously injured or die. And let's take it one step further and imagine, in fact, the child does die. Is that course of conduct sufficient to meet every element of a 2261A, 1A, charge? Mr. Zhang, no, Your Honor. The court, why not? Mr. Zhang, because I have not knowingly engaged in conduct that I know will place the victim in reasonable fear of death or serious bodily injury. The court, but where is that knowingly coming from? Right. Because it's not in the statute. I think we all agree that it's not in the statute. There's no words there that you can read that get you there. So why should I read those words into the statute? Mr. Zhang, okay, so this is the Ellenis point, right? And I think what the Ellenis line of cases, and this goes all the way back to Morissette and cases like that, is that where a statute is silent as to the state of mind that accompanies an actus reus, what courts do is not say, all right, well, there's no state of mind requirement here. What courts must do is read into the statute a sufficient state of mind requirement that would distinguish innocent conduct from culpable conduct. And I think the defendant's primary response to this is, well, there is an intent requirement, it's this intent to harass requirement, but that doesn't work, and here's why. Number one, if we look dramatically at the statute, that specific intent requirement modifies solely the word travels, right? It's travels in interstate or foreign commerce, etc., comma, with intent to kill, injure, harass, etc., close comma, and in the course of or as a result of such travel or presence engages in conduct. So there's a separate word engages that grammatically is not modified by the specific intent requirement, and then that's what leads to reasonable fear of death and serious bodily injury. The court, right, and I think courts have generally agreed, and I think it's a natural reading, the course of conduct has to be some purposeful conduct in more than one event, right, and that it has to be purposeful. I think the gap that you're trying to bridge, right, because Taylor and Davis and Delegati all tell me that I have to identify the element that is, requires the use, attempted use, or threatened use of physical force. So I think, really, so much of the action, right, is right where we are talking about right now, which is what is the bridge, whether primarily a mens rea bridge, between my purposeful conduct and the effect that is produced by that purposeful conduct, which is either that the person is placed in reasonable fear of death or serious bodily injury, or that I'm causing substantial emotional distress, which is not at issue here. But, Mr. Zhang, yes, I think the bridge is the Ellenis principle that you have to include mental state requirements that distinguish between innocent and non-innocent conduct. And just to jump real quick back to Your Honor's originally hypo, that does not strike the government as a crime, what Your Honor has described, and the government can certainly construct other hypos like that, right, where there is interstate travel with an intent to harass, and say it's established by journals or whatever, and say, the stalker checks into a hotel, right, it's not a hotel near the victim, it's not just check into a hotel, interstate travel. Before I start my course of harassment tomorrow, I'm going somewhere to stay, and the victim sees the defendant, right, check into the hotel, and we can construct, for purpose of the hypo, all sorts of historical facts that make it reasonable for the victim to fear, oh, he's come back to town to kill me. I don't think the statute reaches that conduct, right, because basically what we're talking about at that point, forget about Borden and Leocal and negligence and reckless, that's straight up strict liability, and that is not something that, absent very clear congressional intent, should be the natural interpretation of this court. And I really want to make this point about the Ellenis problem does not get solved simply if there is a specific intent. Here's a pretty simple statute that I think illustrates that. Say a state passes a statute that says whoever transports, with intent to earn fee, cocaine shall be guilty of a crime, right? And what is the mens rea that needs to apply to knowledge that cocaine is being transported? Because, on the face of that statute, a regular cab driver who picks up a fare with the intent to earn a fee, right, and the passenger ends up being a drug trafficker who's arrested by the D on the back end, that cab driver would be guilty of this offense, and no court would interpret the statute that way, right? The court would say there's a knowledge requirement as to the drugs. The court, but, Mr. Zhang, isn't that sort of like right at the argument that Mr. Patel was making about his interpretation of Ellenis? The difficulty you have in that hypothetical is that until the thing that tips innocent lawful conduct into criminal conduct is the driver's knowledge that the passenger has cocaine and that the purpose of the trip is transporting the cocaine. Here, I think Mr. Patel's argument is that their interpretation of the statute doesn't create an Ellenis problem because, even with the kind of strict liability like if you have purposeful conduct that produces a certain effect, you're on the hook. There's no Ellenis problem because you already have engaged in conduct that is criminalized in various ways, in all kinds of state and federal statutes, which is engaging in purposeful conduct with an intent to harass or intimidate. Mr. Zhang, so I would disagree with that, Your Honor. The court, okay, Mr. Zhang, I think if we're going to map those analogies on, I think what Your Honor's saying, look, the intent as to the drugs does all the work in that drug, right, hypothetical drug statute. The court, at least in terms of dividing innocent from criminal conduct, Mr. Zhang, understood. I guess what the government would say is that the intent to harass cannot do all the work. Pretend there was a version of 2261A that just stopped at the travel. Whoever travels with the intent to harass, the enumerated categories, shall be guilty of a felony. That's an edgy statute, right? That's just someone traveling who does nothing post-travel, does nothing vis-a-vis the victim, but harbors dark and malicious thoughts in the course of travel. That's not what 2261A is about, right? The travel element is in some sense it's the federal nexus hooked to where the action is, which is the conduct vis-a-vis the victim. So to say that, well, there's this intent requirement that does the work as to the travel, and so don't worry about the Ellenis issue as to the conduct doesn't make sense. What we're trying to get at is intentional targeted conduct vis-a-vis the victim. And going back to my hypo from before, you can construct hypos where the defendant has engaged in conduct that, due to weird Rube Goldberg-like circumstances, leads to some fear by the victim, or even death, that are completely unforeseeable and could not possibly be foreseeable to the person who traveled. I don't think the statute is meant to get at that. The court, so assuming that you're correct and that I should read the statute to require at least knowledge that my purposeful conduct would place a reasonable person in fear of serious bodily injury or death, does that necessarily mean that, in the language of Taylor, that the government is required that in order to find someone guilty of this crime, to convict them a jury is required to find beyond a reasonable doubt that they used, attempted to use, or threatened the use of violence of physical force? if I accept your view that you have to at least have knowledge that your actions would cause a reasonable person to fear, is there any way to accomplish that? Like, could the government prove that case without requiring a finding that a defendant used, threatened, or attempted the use of physical force? 70 Mr. Zhang: No, we couldn't. There's no delta, and that's why we succeed under the categorical approach. I mean, every one of the hypos that the defense has offered, including the hiking hypo today, they all fail for one of two reasons, and depending on, the devil's in the details. Depending on what set of facts, details can be tinkered. It could be one of the two. Either it's the case that it wouldn't be reasonable for the victim, all things considered, to fear death or serious bodily injury. Right, and the word reasonable is doing a lot of work there, but also death or serious bodily injury, as opposed to being generically scared or harassed or emotional distraught. Either that's not reasonable or there are facts that make belief and fear from the victim reasonable, in which case those same facts are the facts that make it so that the defendant at least knows that that reaction from the victim are the natural consequences of his actions. And Borden, of course, reminds us that it sort of doesn't matter whether the defendant intends subjectively in his heart to follow through, right? And he could even, I think in the reply brief they say, what if he really reassures her, hey, I'm not about to kill you? That actually legally doesn't matter. What the legal inquiry there is, based on what the defendant, all the facts that he knows, including all their backstory and history and all of that, does he know that the victim's reaction, the belief as to the conduct that's occurring, is that it would be reasonable for the victim to fear death or serious bodily injury? And if that's the case, then the defendant is at least knowingly engaged in the actual, attempted, or threatened use of force. He's not intending the threatened use of force, but he's knowingly engaging in conduct that he knows, from the victim's perspective, constitutes a threatened use of force, and that's sufficient to satisfy the elements clause. The court, and you'd agree with me, Mr. Zhang, that if I were of the view that that element could be satisfied with recklessness or negligence, that under Borden, it's game over. Mr. Zhang, it's game over. Yes, Your Honor. The court, okay, I thought you would concede that. I just wanted to make sure. I guess part of what just to make sure I understand your argument, Mr. Zhang, it's sort of the flip side of a question I think I put to Mr. Patel, where a number of the other district court cases kind of, in an analysis that I think is maybe not necessarily correct, but they look at, when you put all of these things together, all the parts of the statute together, there's no way for that entire course of behavior to happen without at least the threat, the implied threat, that force will be used. And first, I guess, do you think that's right? And second, do you think that I'm permitted to do that under Supreme Court precedent? Do I have to go element by element and identify where is the element that could potentially satisfy the crime of violence definition and analyze that element in isolation? Or am I permitted to 100K at, well, when you put all of these elements together, you end up at place X? Mr. Zhang, you can look at all the elements together, and here's why, Your Honor. I think the formulation, and I apologize, I don't have the precise cite here, a common formulation, including in the Second Circuit, is what is the minimum conduct that the government needs to prove in order to prove up the statute. The minimum conduct is conduct that includes all the elements. And I think part of what Your Honor is getting at is, well, what if the thing that makes it a crime of violence is split across different elements, or is the kind of interstitial space, shall we say, between two elements? And the government's view is that's good enough, right? I don't think the analysis turns on whether the crime of violence kind of qualifying piece of the statute is in one element or a couple different elements. An analogy that we've been thinking through to think this through, and I know this is silly, say we're not talking about crimes of violence and say, you know, a statute is a certain kind of crime, if it requires, as an element, that you own a square, right? And say the statute under consideration is, well, element 1 is that you have a four-sided shape. Element 2 is that that four-sided shape has sides of equal length. And element 3 is that that four-sided shape have four right angles. I don't think it would make sense to say, look, it's not categorically a square because the square-making thing is split across three elements as opposed into one element. As Your Honor knows, how courts list elements, whether a particular statute has 3 elements, 5 elements, that can even vary across jury instructions. There's no magic to that. I think the analysis, and I think the Second Circuit, and I believe the Supreme Court cases make clear is what we're looking at is what the bare minimum conduct that the government must prove in order to carry its burden is to the statute. Obviously, because it's categorical, not just in this case but in any case. So in a divisible statute where we've charged the death resulting, it's going to include all the elements, including the death resulting element. So to go back to the original question, the government's not saying the death resulting element is doing all the work by itself, but it certainly should be taken into account in that kind of all elements analysis. The court, I know I've taken you over your time also, Mr. Zhang, but I have a few more questions just to the question that I put to Mr. Patel about Taylor and the effect of Taylor on the realistic probability test. And I think when I was pressing Mr. Patel on this, I sort of said, well, you know, there's what Taylor clearly is prohibiting, I think, is a version of realistic probability that puts a burden on a defendant to identify instances or to demonstrate that the hypothetical that wouldn't require the use of force is something that was likely to be prosecuted, such that a court needs to worry about the situation. And I think it arguably leaves open the question of whether a different way that courts have used realistic probability, which is this kind of the hypotheticals exercise basically. Can you imagine a way, consistent with the laws of physics and normal human interaction, where a factual scenario, could play out that would be prosecutable regardless of what any particular AUSA might think about the merits of the case? So what is your view on that? What is the teaching of Taylor, and what should I think remains of the realistic probability test? Mr. Zhang, so the government is certainly not relying on the realistic probability test in the way forbidden by Taylor, and the government's not taking the view that, well, some of these hypos are too far-fetched, therefore, ignore them in the categorical analysis test. I mean, we've been happy to indulge all the hypos. The hypos fail not because they're far-fetched, but because they don't accomplish what they need to accomplish in order to count as a counterexample, right? Which is to simultaneously be conduct that fails the elements clause, but that also puts the victim in reasonable fear. I mean, that's the government's position, not that the hypos are too convoluted and off the wall. I don't know that I would call this the realistic probability test, but I do think what remains fair game is for courts, in considering the scope of the statute and how the statute should be interpreted in terms of what it criminalizes and what it does not, to think about what makes sense. So the sort of arguments, for example, that the government has made to address the self-harm separate from divisibility, is the arguments about, look, on their reading, these things would be crimes. These things are obviously not crimes. They love to talk about examples of people blowing their brains out with a gun. Let's set those aside, right? Some of the government's hypos are not far-fetched at all, right? Someone with a terminal illness saying to a spouse maybe this is to hurt the spouse, to harass, to cause emotional pain. Look, the only reason I was going through with these painful medical treatments to keep myself alive were because of our marriage, and so if you're not going to get back together with me, I see no reason to do that. That conversation meets, on their self-harm argument meets literally every single element of the statute, and I don't think anyone in this is not about realistic probability, but about what makes sense in interpreting the statute. I don't think anyone would interpret 2261A reaching that conduct, and they've never responded to, by the way, that argument in their papers or today. Realistic probability also again, not the doctrine instead itself, but that mode of thinking is relevant to what's the logical upshot of their Plunkett self-harm argument. Well, it means not only that there's a problem with 2261A, it means that there's a problem with all these other statutes which we list in our brief, which are statutes criminalizing literal murders and assassinations and kidnappings of high-up government officials. And in many of those statutes, the statutes protect not only the government official but the government official's family. And so, on their view, all those statutes are no good because it's possible for a member of those government officials' families to be, say, a kind of troubled child who says, in a way that sometimes happens with troubled children, you know, if X, Y, and Z are not X, Y, and Z, I'm going to take a bottle of pills, I'm going to hurt myself. Clearly, that's not what those statutes were intended to cover, that type of factual scenario. Not that those factual scenarios are not realistic, they are realistic. But the separate analysis is should the statute be interpreted to cover that kind of conduct, and b, it would be extraordinary if, as a result of their argument, not only is the court finding that 2261A, a statute that Congress clearly intended to protect, to the maximum extent possible, interstate stalking, domestic violence victims, among others, that those other statutes are no good as crimes of violence and can't serve as 924(c) or 924(j) predicates. That's an extraordinary result and a reason not to read the self-harm possibility in the way that they suggest. The court, well, I mean, if absurdity were the test, we wouldn't be here. We wouldn't be where we are, I think, with this doctrine, right? Because I think any reasonable observer of the application of the Supreme Court's doctrine on categorical approach for these crimes would say that it produces absurd results. So I don't know how much weight I can give to the idea that the real-world consequences would be absurd. Let me ask you just a couple more questions, Mr. Zhang, and then I want to be fair to Mr. Patel, setting aside, for the moment, your argument that a defendant has to intend or know that his conduct will place the victim in reasonable fear. If I don't agree with that, and many of the other cases, Johnson, Ali, Bacon, Griffin don't really engage with that question and, rather, they do more of a like. Well, I am thinking about the ways that this crime could be committed, and I just think any way that it could realistically be committed would have to involve at least an implied threat of violence. And my question is, isn't that, in part, what Taylor prohibits? Justice Gorsuch in Taylor has a lot of criticism for what he views as efforts by the government to backdoor what the residual clause used to accomplish. Let me look at the ways this crime is typically accomplished and assess whether the ways that people do this crime in real life create a substantial risk of force. And in Taylor, the court's opinion is extremely critical of those arguments that the way to think about this is to look at the ways the crime is typically committed, and that rather a very strict textualist approach, element by element, what are the words of the statute, is what is required. And so, again, setting aside the point, if I don't agree with you that a defendant has to intend or know the reasonable fear, do you think the Taylor court would look at these cases, Johnson, Ali, Bacon, and Griffin and say they're doing it wrong? That's maybe not a fair question to put to you, Mr. Zhang, but, I mean, do you understand the analysis they seem to be undertaking seems to me the analysis that was criticized heavily in Taylor, Mr. Zhang, so I don't know that I would quite agree with that. And, look, Your Honor's certainly right that they did not go into the level of statutory parsing that we're going through in this case, but I think, in fairness to those courts, they did fundamentally the right analysis, right, which is actually, with one or two exceptions. There's variations in terms of the language of those decisions, but the core decisions, say, Johnson, right, the type of decision, those judges say, look, I can't think of an example, right, which is exactly the categorical approach question, not, I can't think of a realistic example or I can think of an example, but it's not realistic. But I can't think of an example in which the defendant places the victim in reasonable fear and causes death, and it's not intentional, attempted, or threatened use of force. Look, did they kind of go into this whole Eleanor's question about, well, what is the mens rea that attends to the word engages? They didn't articulate it in quite that way, but I think that is the analysis that they're engaged in. Look, Your Honor is, of course, right that Taylor was very clear about we're not doing the residual clause thing anymore, and to be clear, that's not the government's position here. The government's not saying, has not argued, and should not be interpreted as arguing, look, it would be ridiculous if 2261A were not a crime of violence, therefore, find it to be a crime of violence. That's the old style of argument. I think what we are saying is, separate from the categorical approach question about looking at the elements and the language of the statute, there's also an Eleanor's principle. Before you even get to, is this a proper predicate, you have to be interpreting what does the underlying statute require or not require, and that's the question that Eleanor's gets to, which is when interpreting certain statutes, there may be unarticulated mens rea requirements that need to be read into the statute for it to make sense. And that's not an absurdity argument about the categorical approach, that's a different thing. That is an absurdity argument about just meat and potatoes statutory interpretation, which is something that pre- and post-Taylor courts must do because we have to instruct the jury, for example, properly as to what the government needs to prove and not prove. And, for example, in this case, the government is prepared to consent to, and I think would propose, jury instructions that require the government to prove that the defendant knew or intended to place the victim in reasonable fear of death or serious bodily injury. That is consistent, in the government's view, with what the statute on its face and logically requires, because otherwise you're going to have these scenarios of strict liability causation, like the hotel checking-in scenario that I mentioned or the one Your Honor mentioned where, whatever the intent in his head, driving outside and saying, "I'm right outside," and that's setting off an asthma attack or a death from an asthma attack. That's not what the statute was intended to capture. It's intended to capture targeted activity toward the victim, right? That was what Borden was trying to police, right? On one end, negligence and recklessness, which are about irresponsibility as to risk. Ultimately, that's what those states of mind are. I'm engaging in risky behavior, and I'm being legally irresponsible about the risk that I'm putting out there in the world, but not specifically targeting specific victims. And that's why it doesn't fall under the elements clause and the word against. But, on the other side, knowledge and purpose, I'm targeting the victim. And I think it's very difficult to conceive of 2261A as having a Borden problem where the prerequisite to the statute is that there is a specific victim that the stalker is intending to victimize. The court, all right, before you sit down, Mr. Zhang, and I give Mr. Patel his chance, can you just briefly address the argument in the defendant's January 8 supplemental letter in that Mr. Patel made about Congress stripping the words intend to cause out of this, the pairing of action and effect when the statute was amended in 2013, Mr. Zhang, so I don't think it's fair to characterize what Congress did as stripping anything out. I mean, when the government looks at the statute, it was structured fundamentally differently. I mean, the current statute has a sort of branching four-part structure with 1, a 1b, 2, a, and 2b, and at least when the government read current version of that statute, it looked different. And also, just as a matter of logic, the government agrees that that prior statute satisfies the elements clause and has the requisite intent requirement. It doesn't follow from the fact that the current language of the statute is different that, at least the divisible subsections of the statute that the government has charged here, that they remain crime of violence because they continue to require at least knowledge, if not intent, that the defendant's conduct would cause reasonable fear of death or serious bodily injury. The court, all right, thank you, Mr. Zhang, very much. Mr. Patel, thank you, Your Honor. Okay, so, first of all, I just wanted to start where my colleague left off. It's really difficult for them here to say that there's, or to get the court to say that there's an intentional mens rea because, again, that legislative history is really important. They knew how to put that in there, and just because there's different subsections now there were different subsections then, just because the structure is different, it's bizarre. It would have taken one word to say intentionally put somebody in fear of injury, and they didn't do that. And also, I'm not understanding, how do you get all the way to knowing, right? Like, why isn't it reckless? Why isn't it negligent? That wouldn't make it strict liability. So even if they're right that something else had to be put in there, I don't understand, when the Congress had intent in there and they take it out and now we're just going to go almost to that again because, again, what Borden said is knowledge. Knowledge is a practical certainty that the defendant knows the consequence of his action. And so, in fact, I encourage you to go back and look at what Borden said about knowledge. What the court said is that there's a very, very fine line between knowledge and intentional conduct, and the court said most of the time it's going to be inconsequential because it's so close, right? So the example that was given in Borden is there's a getaway driver. He sees a pedestrian in the street, and he still goes forth and runs into him. That's almost certainty, right? He knows, and so it's basically he's deliberately targeting harm effectively. So that's the type of knowledge that they were talking about, and I don't know how the government gets there when there's not a single word in the statute. So maybe at most give them the benefit of the doubt. Why isn't it reckless? Why does it have to get to knowledge? I just don't know where they get that argument from, Your Honor. And also, one other thing I wanted to address is this parade of horribles that this is going to result in, like other statutes having the same consequences, the ones they cite in their brief. It's 18 U.S.C. 115, it says threat to assault, kidnap, or murder, and it looks like it's indivisible, and you can't kidnap yourself, so I don't think that's going to happen there. The other one they cite also says threats to kill, kidnap, or inflict bodily harm. Well, you can't kidnap yourself, so I don't think that works either, Your Honor. The court, can you just address, Mr. Patel, Mr. Zhang's argument about Flory and that Flory justifies the jury instructions that explicitly told the jurors that they did not have to find that the defendant knew that his actions would cause the statutory effect. And I think Mr. Zhang's argument, in part, was that in the context of Flory, because Flory involved only communications and therefore true threats doctrine had to be applied, that there already was, kind of in the package of what the jury was being asked to do, a finding of knowingly creating a fear of injury. What do you make of that argument that I shouldn't take from Flory that, in the context of the subpart of the statute that's at issue here, where a true threats inquiry doesn't have to happen, that Flory doesn't necessarily mean that the proper instruction here would be an instruction that the defendant doesn't have to know or intend the statutory effect of his actions? Mr. Patel, well, I think what Flory's making clear is that you don't need anything more than was put in the jury instructions, right? And what was put into the jury instructions, I think, was, the instruction that was given is a true threat is a serious threat, not idle talk or careless remark or something said jokingly. That is made under circumstances that would place a reasonable person in fear of being kidnapped, killed, or physically injured. So, again, they were referring back to the reasonable person standard. They weren't saying that it had to be knowingly. It wasn't in there in the jury instruction. That's the way I read it, Your Honor, so I don't think that's of consequence there. Let me see if I have anything else to add. Oh, the other thing I just wanted to point out, Your Honor, is, like, the government saying, oh, well, we can take different positions. We're different United States Attorney's offices, but it's one Department of Justice. And also, if you find today, Your Honor, that the statute is divisible between subsections or even between the different people enumerated in subsection A, then if I was the defendant in U.S. versus Gug, I'm going to say my conviction's invalid. These guys, you know, think it's an element, and it was not a unanimous verdict then. So that's going to be the consequence with all the cases where they have agreed that it's indivisible when it benefits them. Well, if I was the defendant, I'm going to call up these guys and say, okay, let's get your conviction vacated now because there's a decision by a very smart judge who says that it's wrong. The court, I don't know that anyone would say that, but thank you, Mr. Patel. Mr. Patel, anyways, that's my argument, Your Honor. Thank you. The court, all right. Thank you very much. Thank you all. So, obviously, as you can tell by the time expended, I think this is a difficult issue and one that much in this case turns on, so I'm not going to rule on the motion while we're here together. I want to think about it and issue a written decision, but I would like to set a next conference date on the presumption that all of the pending motions that have to be resolved will have been decided by then and so that we're in a position to talk about next steps. I would propose Friday, January 30th, at 11 a.m. if all counsel are available at that time. Mr. Gentile. Mr. Gentile, that works for the government. Ms. Friedman Anafilo, yes, Your Honor, that works for the defense too. The court, okay, so we'll set a next conference date. Again, that will be Friday, January 30th, at 11 a.m. and of course, if, on reflection, I think an evidentiary hearing is needed, I'll reach out to counsel promptly, and we'll schedule it within the next couple of weeks. Mr. Gentile, while, of course, time will automatically be excluded under the statute during the time the motions remain pending, in the event that the decisions issue well before our next scheduled conference. Does the government seek to exclude time under the Speedy Trial Act from today until, Mr. Gentile, we do, Your Honor. The court, January 30th. Mr. Gentile, we do, Your Honor, yes. The court, on what basis? Mr. Gentile, on the basis of allowing the defendant and his counsel to continue to review the voluminous discovery that we've produced so far to date and also to contemplate any other additional motions they may seek to make. The court, Ms. Friedman Anafilo, does the defendant consent to the extension of time? Ms. Friedman Anafilo, yes, Your Honor. The court, I will exclude the time from today until January 30th. I find the ends of justice served by excluding such time outweigh the interests of the public and the defendant in a speedy trial because the capital eligible status of this matter renders it unusually complex and because the potential outcome of the pending motions will require significant consideration by counsel for both the government and the defense of appropriate next steps in this matter, including the possibility of interlocutory appeal or, alternatively, an assessment of the time needed to prepare for a capital trial. Accordingly, times excluded. Mr. Gentile, anything further from the government? Mr. Gentile, yes, Your Honor, with respect to scheduling. Before Your Honor took the bench today and even during the break, both parties conferred, we were prepared to propose a set of dates for trial and pre-trial deadlines. We understand what the court said at the beginning of the proceeding. However, we do want to let the court know that, and I'll let defense counsel speak for themselves, that we feel it's important to set a date, even if it's something that has to be moved at some point. The government, and I'm sure defense counsel as well, has a number of witnesses that are traveling from out of state. We have expert witnesses that we're going to look to talk to and schedule different matters with them. So if we could put something on the schedule now, even if it has to be moved eventually because of the court's ruling in one way or the other, I think that's the party's preferred course of action. The court, okay, well, tell me what you had in mind. Just talking about I do think that if it's going to be a capital trial, I think the preferred course of action, one that I've described with the jury department already, is that we set a date for the beginning of jury selection and then a firm date for the start of the trial, so that we're able to tell prospective jurors this is when the trial will begin, rather than, as has happened in some other cases, where we're telling jurors that the trial will begin when jury selection is over. I don't think that's advisable. So I'm not sure, Mr. Gentile, what the nature of your discussion was, but why don't you tell me what the parties have in mind? Mr. Gentile, certainly, Judge, and we consider that very issue that the court just pointed out. Our proposal is to begin jury selection on the 1st of September, with a non-capital trial to begin in early October, October 12th. Should it be a capital trial, we would propose continuing the jury selection and voir dire, and all of that, and with trial scheduled to begin in early January. The court, well, to the extent I can control the process, I don't intend jury selection to take 3 months in this case. I'm well aware of the time that jury selection took in the Sapov case, but I don't think, given the procedures I intend to use, that we need 3 months. But the party's suggestion is very much in line with what I had in mind. I think what I had in mind was one of two alternatives, either beginning the jury selection process in July with the expectation that we'd start trial in mid-September, or, alternatively, beginning the jury selection in September with the expectation that we'd begin trial potentially the first week of December, if it's a capital trial. So it sounds like where I assume, Ms. Friedman Anafilo, that you think June or July to begin jury selection is too soon if it's a capital trial. Ms. Friedman Anafilo, yes, Your Honor. The court, okay, and I think, on reflection, given the pre-trial filings that would need to be made, if we are proceeding as a capital trial, that probably is a little bit compressed. So while I won't give a specific date while we're here in court, because I do want to look at the calendar and look back at my notes of my discussion with the jury department, I'm happy, if both parties consent, to issue a scheduling order that bakes in an alternative for a capital or non-capital trial on the merits, with the expectation that we'll begin the jury selection, if not September 1st. It may make more sense to begin September 8, it's a very late Labor Day this year, Monday, September 7, but, generally, in the first working week of September, and then with a trial to begin later in the fall or in the early winter. So let me just look at the specific dates, but it sounds like we're all kind of very much on the same page as to how we might proceed, and I'm happy to, at the party's request, issue that scheduling order so that everyone can plan the remainder of the year. Mr. Gentile, thank you, Judge. The court, okay. Anything else, Mr. Gentile, from the government? Mr. Gentile, not from the government, Judge, no. The court, Ms. Friedman Anafilo, anything else the defendant would like to raise? Ms. Friedman Anafilo, no, Your Honor. Thank you very much. The court, all right. Thank you all very much. I found this yes, Mr. Moskowitz. Mr. Moskowitz, Judge, just with respect to the start date of a capital trial, in addition to counsel, we have mitigation specialists, jury specialists that are engaged, so the January date that we were proposing to start was considering their schedules. They're involved in the Gendron, which is going to begin over the summer in Buffalo and likely to last, if not through the end of the year, close to that. So that was the reason we were suggesting a January start date for a trial. The court, okay, so just to make sure I understand, Mr. Moskowitz, the January sort of trial on the merits, if it's a capital trial, is not based on an assumption that it will take us 3 months to select a jury, but rather ensuring that, when the trial on the merits begins, all necessary personnel are available. Mr. Moskowitz, that's correct, Your Honor. The court, okay, that's very helpful, thank you. So, again, as I was saying, thank you all very much. I found this very helpful. I'm always appreciative of excellent advocacy just as a matter of craft, and so I have enjoyed this. I found it very helpful, and I'm very appreciative of the time you've given. And with that, we are adjourned. Mr. Mangione is to remain in the custody of the Marshal's Service. Thank you all. Adjourned.
That was the end of the audio version of the full transcript from January 9th, 2026 for Luigi Mangione's case. So I've realized I've kind of been like speed running, trying to get like 3 videos out this month because I unintentionally took like 2 weeks off for Easter. I think the first week I took off for like Easter because family stuff. Nothing bad happened, I just had to like see the family, and then I spent a week like going over my notes and stuff of all the updates in the Luigi Mangione's case. So lately I've just kind of been like speed running, trying to get you guys like the 3 videos out this month, because compared to like beforehand, I kind of like recently changed my uploading schedule from like a video every week to like 3 times a month. It's a lot easier on me doing it that way. I did it with my old channel before YouTube got rid of that. Like I did a video once like 3 times a month instead of like every week. That was exhausting. I'm new, like my new uploading schedule. I think it makes it a lot more easier to handle all this instead of like me rushing, because holy shit, these videos are big. This month I've like been kind of like rushing, trying to get you guys the 3 videos this month, so this uploading schedule works a lot better for me to like, you know, not panic. Like holy shit, how the fuck did I do that? Like 1 video every week, holy shit. That was exhausting. I was burning out honestly at that point, so smart move on me for changing it to like 3 times a month instead of once every week. I don't understand how people do that. I guess they have a little team. I think that's how they can do it. Or their stuff is like incredibly easy to edit. Sorry for like the uploading schedule being a little bit all over the place this month, being incredibly close together, because I'm like trying to upload the 3 videos this month instead of, you know, 1.5. Thank you for watching this week's video. You can subscribe if you want to, it's okay if not. I upload 3 times a month, and if you guys want to keep up to date with the channel, what things I'm working on, my little shorts and stuff that I don't post on YouTube because YouTube doesn't like shorts when I talk about Luigi, you can go follow the channel's social medias. That's where I post updates and all that, and my little shorts and all that. So you can go follow the channel's social medias, and that will be in the description down below. And if you guys want to follow me personally, all of my social medias are down below as well. Bye!